Well, what we have now is nothing short of a smackdown. We have not one, not two, not three, but 4 amicus briefs in Concord Music v. Anthropic. And they are epic. They are going straight after this theory of dilution. We're going to focus on one because one of them is really good. It's written by a couple of copyright attorneys who really know how to make these arguments. We'll look to a lesser extent at the other 3 because they kind of fill in some holes, but primarily it's this first one. But the whole market dilution theory, it's basically an act of desperation, because without it they would have already lost completely, not just Concord Music, but all of these others we've been covering, which is why you hear me talk about this a lot. That 4th fair use factor, they lose mightily on the first 3. They really lose on the 4th one as well, and that's why they have to kind of cook up this theory of market dilution, which is a novel new theory that all of these amici are going to smack down hard. And as a bonus, they'll hit another concept that we mostly see over in the image generation cases, but here we have it in the music case. This idea that you can copyright a style. No, you've never been able to copyright a style. People saying, oh, they're making images in my style. They're making music in my style. It's music in the style of Taylor Swift. So what? You can't own that. You only own the expressive elements. So let's get into this. This is from copyright law professors Edward Lee and Rebecca Tushnet, and they're quoting Bartz v. Anthropic, Judge Alsop. The technology at issue is among the most transformative many of us will see in our lifetimes. That counsel's great care in deciding whether to apply novel, untested dilution theories that might unduly impair technological development or expand copyright beyond limit. Even assuming Anthropic's LLMs memorized all the works on which they were trained, and they didn't, we've been over that many times, Judge also concluded that the purpose and character of using works to train LLMs was transformative, spectacularly so, and using copyrighted works to train LLMs to generate new text was quintessentially transformative and a fair use. Which should have been the end of it. Sadly, it wasn't, which is why we're doing all these videos. But if you ever run into anyone who's talking about this market dilution crap, this is what you lay on them. This court should also reject plaintiffs' assertion of putated market harm based on an unprecedented theory of copyright dilution, that is, mere competition from non-infringing outputs. The First Amendment favors, not stifles, competition in the marketplace of ideas among non-infringing works of expression, which is something they've said in several of the cases. Oh, the AIs are just going to generate millions of books, or they're just going to generate tens of thousands of songs, and they'll all compete with us. So what? It's just competition. Copyright isn't there to protect you from competition. Because plaintiffs now seek to dismiss with prejudice both of their secondary liability claims, the alleged infringing outputs of Claude users cannot be imputed to Anthropic if the claims are dismissed, which is another big consequence the Cox decision is going to have, because now it's much harder to make those secondary liability claims, but without it, you can't hold an AI company responsible for infringement by their users. Plaintiffs deny AI training is fair use, but they do so only by ignoring the important transformative purpose of scaling to develop better AI models and radically expanding their copyrights under a new theory of dilution to encompass entire genres of songs. Stretching copyright to encompass genres via dilution is unconstitutional. Under the Copyright Clause, plaintiffs' copyright extends only to their respective writings, not entire genres. And they go into detail on why it's transformative. We don't need to go over that again. We've covered that more than sufficiently for any reasonable person. So let's just focus on this dilution claim, which is really all they have left. Although plaintiffs assert that copyright dilution is consistent with long-established copyright jurisprudence, their argument rests on 2 recent and non-precedental authorities, dicta in Condre, in which the parties did not even brief the dilution theory, and the court unsurprisingly found the plaintiff's lack of evidence rendered that theory too speculative, and a short statement in a non-final pre-publication Copyright Office report with no legal force. And you've seen the anti-AI people online probably sharing this thing like it's gospel. See, it's from the Copyright Office. Because as they say down here in a footnote, the Copyright Office's terse explanation does not qualify even as persuasive authority under Skidmore v. Swift. The office did not discuss the requirement of cognizable market harm under fair use precedents, nor did the office acknowledge the serious constitutional issues raised by dilution, in sharp contrast to its report on moral rights that admonished any changes to the law must comport with the First Amendment, fair use, and constitutional requirement of limited copyright terms. So that's completely irrelevant. Stop sharing it. You just make yourself look like an idiot. Both acknowledged that dilution was a new theory, or, as the office conceded, uncharted territory. But dilution is not just uncharted, it is unconstitutional. To treat works that copy no protected elements of plaintiff's 499 works as causing cognizable harm simply because they're in the same genre violates the Copyright Clause and the First Amendment. The canon of constitutional avoidance compels the rejection of this uncharted theory of dilution, nowhere mentioned in the Copyright Act. No one may claim copyright in facts or ideas because they're not original expression of authors. A fundamental principle of copyright law is that everyone can build freely upon the ideas and information conveyed by a work. Unprotected elements of works are free for all to copy. The same exclusion of unprotected elements applies to genres and general music styles. They are unprotected elements, just ideas or methods for structuring a common format of music. Genres are building blocks that belong in the public domain and cannot be exclusively appropriated by any particular author. Applying this same exclusion to book genres, Judge Alsop rejected the Bart's plaintiff's argument for dilution because genre consisted nothing more than an idea or method of operation. In a word, the plaintiff's dilution theory was unthinkable for copyright law to accept. Yone v. Paramount Pictures is instructive. The movie studio made the movie Top Gun based on its license from the author of a factual magazine article about the Top Gun aviator program. Later, his heirs terminated the license to Paramount Pictures, which still made a sequel called Mavericks. His heirs sued because Paramount did not obtain a license, but the Ninth Circuit upheld the grant of summary judgment to Paramount. To show unlawful appropriation, plaintiffs must therefore demonstrate that the works in question share substantial similarity in protectable expression, not merely in facts, ideas, or concepts. But his heirs asserted similarities between Maverick and the article only at such a high level of abstraction that the similarities do not involve protected expression. In sum, what is protected is not similar, and what is similar is not protected. Dilution is without any precedent and is an erroneous position given it is not only contrary to the statute, but is not based on there being any infringement at the output stage. And once again, all you anti-AI people need to get over this. Denying fair use violates the First Amendment. This is a free speech issue. Denying fair use based on dilution from non-infringing expression violates the First Amendment. People who use Anthropic's LLMs to create non-infringing expression of their own are engaged in expressive activities protected by the First Amendment. Speech activities under the First Amendment are broad and do not depend on qualifying as works of authorship. Two traditional contours of copyright law that serve as built-in First Amendment accommodations are the idea-expression dichotomy and fair use. See? When they tell you that fair use isn't about the First Amendment, they are lying! Dilution radically alters and undermines both. Genres are ideas or concepts beyond copyright scope. Fair use has never treated wholly non-infringing expression as cognizable market harm. Dilution significantly alters both doctrines, necessitating First Amendment scrutiny. But if applied to deny fair use, dilution jeopardizes everyone's ability to use Claude to create any non-infringing lyrics. And an injunction like the one plaintiffs seek here, where the works at issue are non-infringing and the only similarity between works amounts to unprotectable genres, would be the most restrictive means possible, banning a whole category of speech, lyrics, from people's creative activities using Claude. And setting a dilution precedent here will no doubt affect many other types of works in other cases involving other LLMs alleged to be dilutive. And it's even discriminatory because it unfairly targets AI users. Dilution targets only people who adopted AI as part of their creative expression. This targeting of AI creators alone is unconstitutional. People's choices in adopting a new technology reflects their own perspective and ideological belief in the value of adopting the technology. New technologies compete with old ones, and this competition is a clash in ideologies and worldviews. Many criticisms of AI and outright vitriol against AI slop were submitted to the Copyright Office's study that endorsed dilution. John Philip Sousa once said the phonograph would destroy music. The painter Paul Delaroche exclaimed of photography, "From today, painting is dead." Musicians feared software-based music production would replace human artists. The past fears of new technologies were unfounded, and more speech, not less, is the governing rule in the United States. Some view AI creators as second class, but the law may not do so. Under the First Amendment, one person's slop is another's lyric. I mean, just those portions of it show you what a smackdown this is. You can read the whole thing yourself. It's linked below, 21 pages, not too long. But I did want to get a few things from the other Amici, because they're kind of filling in a few holes. This first one is from the Computer and Communications Industry Association, AI Progress, and NetChoice. And they remind us that the purpose of the Copyright Act, and of fair use in particular, is to promote progress, not protectionism. I love that they use that word, because that's exactly what they're wanting here, protectionism. The exact same thing that made our founders dump tea into the harbor. Plaintiff's argument misapprehends the purpose of copyright and fair use, as well as generative AI's function as a tool in assisting with, rather than replacing, human creativity. The Copyright Act carefully balances incentives to authors as one mechanism to promote publication against other interests, including the public's access to information and the ability of others to build upon earlier work. The Act has never accorded the copyright owner complete control over all possible uses of his work, which is exactly what the copyright cartels are trying to get. Rather, the Act grants only certain enumerated rights and creates a limitation for fair uses that serve the public interest, even where those limitations diminish the incentives otherwise granted to authors. Each of these features reflects the same structural judgment. Copyright exists to serve the public's interest in more access to more useful information, and the exclusive rights it confers are calibrated to that purpose. The Supreme Court has accordingly recognized that copyright does not grant incumbents a veto over new technologies merely because they introduce competitive efficiencies or alter established markets. History confirms the point. Nearly every major technological disruption in the production or distribution of creative works was met by predictions from incumbent rights holders that the new technology would destroy creativity. The educational publishing industry worried that photocopiers and their widespread use by librarians and educators would eviscerate the market for their works, but the industry grew alongside photocopying and attendant benefits to science and scientific progress. The movie and television industry predicted that home video recording would be its undoing. The Supreme Court held otherwise. Today, plaintiffs claim that generative AI models trained on song lyrics will somehow replace songwriters. In each prior instance, the technology that incumbents opposed resulted not in less speech, but in more. More creators, more works, more competition, and broader public access to creative expression. Plaintiffs' arguments in this case are the latest iteration of a familiar and wrong-headed refrain. And while we're at it, let's kill one of the biggest misconceptions about AI. Plaintiffs ignore how AI models are actually used. Generative AI models are tools built by human developers, deployed by human users who supply the intent, judgment, and editorial selection that drive the creative process. In each case, the human user remains the locus of creative decision-making. The model is the instrument. The Supreme Court settled more than a century ago that creative works produced using new technologies remain the work of human authors. The court upheld copyright in a photograph, rejecting the argument that photography involved a merely mechanical process incapable of supporting authorship. The photographer's selection and arrangement of the subject, positioning, lighting, costume, constituted the requisite original intellectual conceptions. For the same reasons, works created by humans using GenAI tools remain subject to copyright protection. To restrict the ability of these actors to develop and use AI tools for public benefit would subordinate the constitutional purpose of copyright to the protection of incumbent business models. Fair use exists precisely to prevent that result. The Ninth Circuit has also long rejected copyright as a means of controlling competition. Plaintiff's dilution theory is premised on the same market control that the Ninth Circuit has rejected. As Judge Alsop explained in Bart's, the fourth factor focuses on actual or potential market substitution and points against fair use when a copyist makes copies available that displace demand for copies the copyright owner already makes available or readily could. But plaintiff's dilution theory does something different. Authors' complaint is no different than it would be if they complained that training school children to write well would result in an explosion of competing works. This is not the kind of competitive or creative displacement that concerns the Copyright Act. The Act seeks to advance original works of authorship, not to protect authors against competition. While copyright's built-in free speech safeguards are generally adequate to address First Amendment rights, that presumption does not hold, and further First Amendment scrutiny is required when the traditional contours of copyright protection have been altered, as they want to do here. Plaintiffs here concede that users are generating new lyrics with Claude. Dilution theory condemns those new non-infringing lyrics and the messages they convey as harmful, and thus represents a significant expansion of the traditional contours of copyright protection. The court need not engage in a detailed First Amendment analysis because long-standing copyright jurisprudence makes clear that it will be antithetical to the Progress Clause and Fair Use Doctrine to allow copyright owners to suppress technology that enables the creation of competing but non-infringing speech. Plaintiff's dilution theory can and should be rejected on that basis alone. Now, in addition to that, we've got another great one from the EFF. And I really like where they're going with this because they're trying to fix a lot of the problems with Warhol. By facilitating users' creation of expressive works, GenAI aligns with copyright law's constitutional purpose to serve as an engine for new creativity. Plaintiffs fundamentally misconstrue both copyright law and empirical reality to pretend otherwise. Copyright law as a whole, including the Fair Use Doctrine, exists to promote the development and availability of both expressive and non-expressive innovation, not a particular kind of human creation done the old-fashioned way. And plaintiff's fundamental premise that AI models merely generate digital facsimiles of human authorship at the push of a button ignores the millions of users choosing and pushing those buttons. Plaintiffs claim that the purpose of copyright is solely to protect human creation offers an improperly cramped view of copyright law. And they go over a lot of the ones we've covered: Sony v. Universal, Perfect 10, Ariba, Authors Guild, iParadigms. And they say, these holdings reflect, as they must, a determination that those users also serve the purposes of copyright, whether or not they were tied to the creation of new copyrightable works. And that's going into Campbell, and further, Warhol did not signal a sea change in the fair use analysis. To the contrary, the court expressly reaffirmed landmark fair use cases like Campbell and Google. Accordingly, there is no need to closely scrutinize pre-Warhol decisions and undermine the legal certainty that has supported technological innovation for decades, including socially beneficial uses of machine learning, such as facilitating academic literature reviews, enabling medical discovery, identifying and tracking misinformation, reducing bias in translation tools. Plaintiffs and Amici also misconstrue users' role in the creation of new works with the assistance of AI, denigrating those works as mere imitations of human expression that will smother the human creativity of others. AI is hardly the first technology to engender claims like these. The camera is a paradigmatic example. Before 1909, the U.S. Copyright Office wouldn't register copyrights in photographs on the theory that cameras created them, not humans. Over time, of course, lawmakers realized that photography could be deeply creative. Indeed, the advent of instant cameras and eventually the smartphone democratized human creativity by making it possible for more people to create images. That same dynamic is already underway with AI. Plaintiffs portray AI-generated works as orthogonal to human authorship, but AI-generated works are more commonly AI-assisted works. AI is just the tool. You gotta bring the creativity and judgment and purpose and everything else to it. And here's another really important point. What is more, AI tools can support artistic creation and information by people with disabilities, for whom traditional artistic forms and sources of information are often inaccessible. These important tools are not plainly infringing as Amici contend. To the contrary, these accessibility uses are paradigmatic fair use. For example, AI image generators allow people with motor impairments to create images by describing their creative ideas through prompts entered using voice-to-text software, rather than using traditional tools like pens or paintbrushes, which may be difficult to grasp or manipulate. And the AI-generated summaries that some Amici seek to prevent from competing with their content are an important source of information for blind and low vision users, because they are often more accessible than many websites and traditional web search tools. Plaintiffs and their amici ask this court to depart from well-established fair use principles and adopt a novel market dilution theory which would insulate copyright holders from hypothetical competition from non-infringing works created with the help of AI tools like Claude. This theory contravenes 300-year-old copyright principles and would impede future creative expression. And oh, but license, we just need to create a market for licensing. Nor does the existence of a limited licensing market for training data tilt Factor 4 against fair use. The Supreme Court has cautioned against the danger of circularity posed by considering new licensing opportunities, because it is a given in every fair use case that plaintiff suffers a loss of a potential market if that potential market is defined as the theoretical market for licensing the very use at bar. Not surprisingly, plaintiff's circular argument has already been rejected by 2 federal courts. In Cadre, this market is not one that the plaintiffs are legally entitled to monopolize, and Bart's market for AI training data licenses is not one the Copyright Act entitles authors to exploit. Further, contrary to Amici's claims, licensing agreements with trillion-dollar companies to train AI models will not promote the development of better technology or competition by small developers. Yeah, the small and open source developers would completely lose out with that. All those models just people are doing on their own and uploading to Hugging Face, they disappear. But a requirement to license millions of works for training purposes would raise massive barriers to entry for smaller competitors. Indeed, until recently, a lack of access to adequate training data was a major impediment to participation in many areas of generative AI research, limiting research progress. So you gotta let them do that. If you let this theoretical market thing stand, then fair use is dead, because you can always say there would be a market for fair uses. And that's ridiculous. Okay, last one from the Chamber of Progress and Engine Advocacy. Again, not going over the whole thing, just filling in a few holes. Starting with a very important concept. The bargain inherent in copyright is to promote the creation of works to advance science and the useful arts by granting authors specifically defined and limited exclusive rights over their own work. Engrafting market dilution onto the fair use analysis upends this bargain. It grants authors rights over the works of others, turning copyright into a competition law, more accurately, an anti-competition law, which is what they want. They want control over everything you say and do online or in public. According to the plaintiffs and their amici, if too many works compete for public attention, those who represent copyright owner interests will find it harder to earn their share of the royalty pie. But even if plaintiffs could back up their claim of an explosion of competed works, dilution of a market for similar non-infringed works is not the kind of competitive or creative displacement that concerns the Copyright Act. The Act seeks to advance original works of authorship, not to protect authors against competition. That's from Sega v. Accolade. Taken to its illogical end, the dilution argument made here by plaintiffs and their amici explicitly asks the court to prevent AI from creating competitors not just to lyrics, but also to music, visual arts, software code, and all forms of literature, an absurd and unconstitutional result. And they do mention one of the problems that come out of Warhol, where plaintiffs and their amici improperly conflate the distinct first and fourth factor inquiries. The copyright cartels are always trying to glom those together. The potential market effect of a use is not dispositive of whether a use is transformative and on balance a fair use. Although the commercial or non-profit purpose of the copyright is relevant under Factor 1, it is not dispositive. It is to be weighed against the degree to which the use has a further purpose or different character. In other words, as I've pointed out many times before, the more transformative it is, the less the other factors matter, including the commercial nature of it. Thus, commerciality under the first factor is not dispositive, as the transformative purposes of the use may outweigh actual market harm. Over the last 5 years, the Supreme Court twice has considered the transformativeness inquiry under the first factor in Google v. Oracle and Andy Warhol Foundation. While plaintiffs and their amici suggest Warhol signaled a sea change in the law, the court's holdings reaffirmed existing principles and applied the statutory text to a novel fact pattern. Fair use is a flexible concept, and its application may well vary depending on context. The court expressed no opinion as to the grounds on which the district and circuit courts had decided the case, namely whether the creation, display, or sale of the Warhol paintings incorporating the Goldsmith photographs of prints were fair uses. Although they should have, because it absolutely was. But the Supreme Court are wimps, and we know it. Instead, consistent with the text of the first factor requiring an analysis of the purpose for which the copyrighted work is being used, the court focused on the purpose of the use at issue. Andy Warhol Foundation's commercial licensing of Warhol's painting based on Goldsmith's photograph for a Prince Memorial Edition magazine cover. Regardless of whether Warhol's purpose in creating the orange prints was transformative, the court held that the Foundation's commercial use displaced the licensing of the photograph from Goldsmith. Barnes v. Anthropic applied the Warhol framework by separately evaluating each alleged use of plaintiffs' copyrighted works. Use of the works to train LLMs to receive text inputs and generate new text responses was quintessentially transformative. So you might be able to apply Warhol to a specific output that's being used a specific way, but not to LLMs in general. Nothing in the court's analysis turned on or was limited to specific types of fiction or non-fiction literary works authored by the plaintiffs. There is no reason why the same transformative uses to train and generate outputs from Anthropic's GenAI systems would not apply to the copyrighted song lyrics at issue here. Plaintiffs' licensing agreements thus amounts to a presumptive, if value then right, proposition which ignores the principled limits on a copyright owner's commercial interests imposed by the Constitution, the Supreme Court, and the collective application of all four Section 107 factors. If Congress wanted to enact a dilution concept for copyright law, it knows how to do it. 30 years ago, in the exercise of its power under the Commerce Clause, Congress enacted a statutory dilution cause of action and remedy for famous trade and service marks. Courts have been careful to caution against misuse or overextension of trademark and related protection into areas traditionally occupied by patent or copyright, which is why they're starting to make a lot of these things trademark cases as well. For the same reasons, this court should reject plaintiffs' invitation to rebalance the goals and incentives of copyright law. Moreover, there's no need to do so. The motions can readily be resolved on the evidence. Here, the evidence shows that AI technology will be harnessed by the music industry for their benefit as well as for the public. They've already admitted that. So for all these reasons, this court should resist the invitation to create new laws based on unsupported and unproven presumptions that could stifle the rapid and undeniably socially beneficial development of AI systems. The court should reject plaintiffs' novel and speculative market dilution arguments and continue to assess infringement, fair use, and market effects on a work-by-work basis as the Constitution, the statute, and copyright jurisprudence require. So man, I think all four of these together is just a complete takedown of this whole dilution argument and how, oh, they're using our styles. No, that has no relevance. You can't own a style. Hopefully the courts see it that way, because if not, it will adversely affect everything you and I say online. This is an important issue, and if you agree, then please, comments for the comment god, shares for the share throne, please hit like, subscribe, and the bell, and of course, donate.bogosity.tv to keep me doing this with one-time payments or regular support. Thank you so very much for watching. Until next time, stay strong and be free.